Wes. Good afternoon. Thank you very much to Azel for the invitation. It is a real pleasure to be here today and to moderate this fantastic panel. All our speakers have extensive experience in the field of international arbitration and public international law. And although none of them really needs any introduction, I will still say a few words for those who may not be familiar with their work. So Naomi Briercliffe is a counsel at Allen & Overy in London, where she represents clients in international commercial and investor-state arbitrations. She has also advised on state-to-state disputes, including before the International Court of Justice and the Iran-US Claims Tribunal. Naomi also provides advice on public international law matters and has been described as a rising star and future leader with remarkable expertise in public international law. Wesley Pydiamah is a partner in Eversheds, Sutherland's arbitration department in Paris, where he specializes in international commercial arbitration, investment arbitration, and public international law matters. His experience includes dozens of cases where he advised and represented governments, state entities, and private multinational companies in arbitration proceedings. He has also experience in proceedings before the Iran-US Claims Tribunal. He has been described not only as a rising star, but also as a strong advocate and strategist. Tino Schneider is a counsel at LALIVE, where he specializes in international commercial and investment arbitration, with a focus on disputes involving construction projects, intellectual property, merger and joint venture agreements, and issues arising in the energy and transportation sectors. He has been described as a supremely talented lawyer and a strategic mastermind with outstanding analytical and cross-examination skills. Last, but definitely not least, Eduardo Silva Romero is a partner and co-chair of Dechert's International Arbitration Global Practice. He focuses practice on arbitration matters, particularly disputes involving states and state entities, and he acts both as counsel and arbitrator. He is a former Deputy Secretary General of the ICC International Court of Arbitration, and he has repeatedly been recognized as an expert in international arbitration and public international law. And having had the chance to work with him in the past, I can only attest to that. Today's discussion will revolve around one main question. To what extent, if any, has the concept of legitimate expectations in domestic legal systems, particularly in national administrative laws, shaped the principle of legitimate expectations in public international law? Before we dive into this, I will just briefly frame the discussion. And the discussion starts in investor-state dispute settlement. In the past 20 years, an increasing number of arbitral tribunals in investor-state disputes have come to recognize that a state's breach of an investor's so-called legitimate expectations may be relevant to decide on a violation of an investment treaty. Although these legitimate expectations can take different forms, such as contractual undertakings or specific representations or assurances by the state, legitimate expectations are generally understood as a legal protection of an individual against harm caused by a public authority who retracts from a previously public stated position or a commitment on which the individual relied upon. The recognition of an investor's legitimate expectations in the context of investor-state dispute settlement is particularly interesting, considering that the text of most investment treaties contains no express reference to legitimate expectations. Tribunals have mostly come to protect the investor's expectations in the context of the state's obligation to provide fair and equitable treatment to an investor's investments. However, most investment tribunals provide very little justification for this. Dr. Michele Potesta has observed that the technique that has been used by most tribunals to buttress the application of the legitimate expectations principle is simply to refer to previous arbitral awards, which have endorsed such concepts, and just use a cascade effect. So each tribunal refers to decisions of previous tribunals. Interestingly, the tribunal in TechMed versus the United Mexican States, one of the first cases to refer to the protection of legitimate expectations, found that the commitment of fair and equitable treatment is an expression of the good faith principle recognized in international law, and went on to say that the fair and equitable treatment standard, in light of the good faith principle, required states to provide to investments treatment that does not affect the basic expectations a foreign investor had when making an investment. Ever since, many commentators have questioned whether it would not be more appropriate to inform the content of the fair and equitable treatment in investment treaties by referring to principles of law, such as legitimate expectations that are already embodied in national legal systems. This is precisely the case of legitimate expectations, and taking into account doctrines of legitimate expectations in the various domestic legal systems and also in investment law, we come to the broader question of whether it is possible to talk about an obligation for states to protect legitimate expectations under customary international law. And so we propose to approach today's topic in two blocks. In the first block, our speakers will give us an overview of legitimate expectations in domestic administrative law, with a focus on the jurisdictions in which each of them is specialized. So the UK, France, Germany, Switzerland, and Latin America. And we will then turn to a comparative analysis to analyze to what extent, if any, the concept of legitimate expectations at the domestic level has contributed to the evolution of a concept of legitimate expectations in public international law. So for this first block, I would like to start with Naomi. Naomi, it is my understanding that the doctrine of legitimate expectations was first developed in English law as a grounds of judicial review in administrative law. What can you tell us about this concept in the United Kingdom nowadays and prior to today?
Thanks very much, Sofía. And first, I'm just going to apologise for my voice. I've managed to get a cold over the last couple of days, but I hope that it doesn't affect the clarity of what I'm saying too much. You're completely right. The concept of legitimate expectations arises in English law as a public law concept. And it's rooted in the constitutional principle of the rule of law, requiring regularity, predictability, and certainty in a government's dealings with the public. Now, in English law, the precise contours of the concept remain in a bit of a state of development, but in essence, it recognises that in addition to observing obligations imposed by law, a public authority may be required to act in a certain way where people have an expectation as to the way in which you will act, based on that public authority's statement or conduct. So, for example, if an authority has distinctly promised to consult those affected or potentially affected by a change of policy decision, then it has to consult them. And if an authority has promised to preserve an existing policy for a specific person or group of people who would be substantially affected by a change of that policy, then ordinarily it has to keep that promise. And then if without any promise, it's established a policy distinctly or substantially affecting a specific person or group who in the circumstances was reasonably entitled to rely on its continuance and did so, then ordinarily it has to consult before effecting the change. So you can see from those examples that it's not just procedural expectations that are protected, such as the expectation of being consulted. Substantive expectations, such as the expectation to continue to receive a particular benefit, are also protected, although that's a development that has come later in English case law. Wes, do we need to pause? Wes from ASIL?
No, I think you can keep going. Sorry about that.
Okay, no problem. So as I was saying, substantive expectations, the protection of substantive expectations was recognised relatively late in English law. Now, it's important to note that judicial reviews granted on the basis of legitimate expectations in England are relatively rare as compared with judicial reviews granted on other grounds. And the reason for that is that the courts recognise the need for public bodies to change their policies and not to fetter their decision-making powers. The courts tend to afford public authorities a measure of deference, particularly where substantive benefits are concerned. It's an applicant's burden to prove that they had an expectation. And then if they did, and it was prima facie frustrated, the defendant, so that's the public authority, has to prove why the frustration was justified. and the court will only grant a remedy if the authority's action was so unfair as to constitute an abuse of power. So it's quite a high threshold. And the question for the court to consider in determining that is whether the impact of the frustration of the expectation on the individual or group in question is greater than the wider public interest in departing from it. So it's a bit like a proportionality analysis, although that's quite a controversial thing to say in English law. So I think I've got a bit more time, so I'll briefly set out some of the factors that the English courts have considered in determining whether an expectation existed in the first place. And because I think you'll see that many of the factors are similar or quite similar to those often considered by investment treaty tribunals in dealing with legitimate expectations there. So the courts will consider things like, was the assurance from which the expectation is alleged to arise clear and unambiguous? Was it directed to or applied to the individual specifically? Was it reasonable for the individual to rely on the assurance? And note that under English law, an expectation may arise from general policies or assurances applicable to the public at large. They don't have to be made to a specific individual or group. And obviously, whether that's the case in investment treaty arbitration is something that generates quite a lot of controversy. However, under English law, it's accepted that government has the power to formulate and reformulate general policy where there are rational grounds for doing so, even if the policy was expressed to apply to a specific date, unless there is some reason why doing so would amount to an abuse of power. As to whether it was reasonable for an individual to rely on an assurance, the English courts, like an investment treaty tribunal, will look to the context in which the assurance was made, and they'll consider all the facts. So, for example, the English courts have held that it's not reasonable to rely on comments made by way of general advice or in political manifestos, for example, because they're not intended to be commitments that anyone can rely on. And then in considering whether there's been a frustration of expectations, one thing the court will consider is whether the individual relied on the promise or practice, but the majority of cases have held that reliance is not an essential factor. So there's a difference with investment treaty law. In particular, reliance isn't necessary if a public authority has failed to apply its then current policy to a particular individual. Indeed, it's not even necessary in that context for an individual to know about the policy or to have known about the policy. That's because there's a general expectation that a current policy will be applied consistently, whatever it is. Reliance is also less important where the expectation is procedural rather than substantive. However, if someone is making an argument that they should have been entitled to the continuation of a particular policy or benefit that's been rescinded or modified, then case law shows us that the individual in question must generally have relied on the benefit in the first place. So then that sort of takes us back to the investment treaty position. I think I should probably stop there in the interest of time and hand over to the next person.
Perfect. Thank you so much, Naomi. Yeah, it's really interesting to see how it comes and goes, whether it's close or not to the position that investment tribunals have taken. Wesley, let's turn to you. Although France has a very developed administrative law system, I understand that the Conseil d'État does not recognize the protection of legitimate expectations per se. What can you tell us about this?
Thank you, Sofía. I'd like to thank Asil and Laura Zielinski, who's probably one of the attendees who organized this. So thank you very much. I won't go into the detail as much as Naomi did, because the French do things differently as the UK, as always. But you're right, Sofía. In French administrative law, there's no recognition of the concept of legitimate expectations per se, but there are similar concepts or theories which are very close. The first one, which is well known, which under French administrative law and which has been developed by the Conseil d'État, which is the supreme body of the administrative law court system. It's a case which is known as dam caché. So sorry, I can't translate that, but that's a decision in 1922. So under this theory, once an act of an administrative authority has conferred rights to an individual, these rights can no longer be challenged. It's a concept of droit acquis, which is the equivalent of vested rights. These vested rights only target specific individual measures which are capable of granting rights. So it doesn't target regulatory acts, but the regulatory authorities are still limited by rules prohibiting, for instance, retroactivity, which is aimed at ensuring legal certainty. So that's the second concept of the vested rights. It's the concept of legal certainty, sécurité juridique in French. That's a concept recognized by the same body, the Conseil d'État in 2006, in a case called Société KPMG and others. There are two aspects to legal certainty under French administrative law. It's firstly the prohibition of retroactive effects, and secondly, transitional measures must be enacted where the immediate application of the modification of the regulatory act would result in excessive interference with existing contractual situations. So that's the second concept, legal certainty. There's a third concept which has been developed recently. It's known as espérance légitime, which I can translate in legitimate hope. So we are getting close to legitimate expectations, but not there yet. So that's a case in which was decided by the Conseil d'État in 2008. It's a case known as Société Getcom. What the Conseil d'État said in that decision, it says that the hope, that legitimate hope, must have a clear legal basis and has to be balanced out with public interest considerations. So we get closer to the concept we know in the ISDS system, but not there yet. There was a fourth concept which commentators and the doctrine thought that it was getting close also to legitimate expectations. It's the concept of confiance légitime, legitimate trust. But the Conseil d'État, in that case, ruled that it wasn't close, or it couldn't amount to one of the three concepts I've described before. And I found this interesting because the concept of confiance légitime we'll come to it later in the discussion, was referred to in one investment case, which didn't involve France, but it was relied upon by the tribunal. So maybe, but we will come to that discussion later on. I'll just note, because it's interesting, although French administrative law does not recognize legitimate expectations as such, there is a BIT which was entered into by France and Colombia in 2014. I'm sure Eduardo will know that better than I do, but it does refer specifically and explicitly to legitimate expectations in the BIT. And it goes even further than that. It does include a definition of what legitimate expectations should be understood. And there was a protocol to that BIT, which was entered into in August 2020. So it's very recent. I never knew that the French administration worked in August generally, but it seems they were working in August 2020. But for those who are interested, it's worth looking at that BIT. So basically, it says it defines legitimate expectations. I'm looking at the text and I'm trying to translate because I don't have an English version. So it's specific representations made by one of the contracting parties to the investor with a view to encouraging an investment which created a reasonable expectation that motivated the investor's decision to make or maintain the investment, but which were not complied with by the relevant contracting party, meaning the relevant public authority of the host state of the investment. So that's an interesting precedent. I'm not aware France has entered into any other BIT where you have a definition of that sort. So it might translate a certain evolution, which is not present in the domestic system, but is on the international law level. France is recognizing that concept. Thank you. I don't know if I've spoken too much, but probably it's good perhaps to turn to the next speaker.
No, it was perfect, Wesley. Thank you. That's really interesting, the BIT between France and Colombia, because it's one of the few that recognize legitimate expectations. And it's interesting that they say that legitimate expectations must consist of specific representations, which already narrows a lot the scope of what can be considered a legitimate expectation. And also the concept of espérance légitime under French law. It's interesting because I think that a hope is even vaguer than an expectation. So a legitimate hope, I mean, it's hard to pinpoint. So we now move on to German and Switzerland. Tino, I understand that German law protects legitimate expectations and has even contributed to the development of the principle under European Union law, probably. So what can you tell us about German and the Swiss law perspective?
Thank you, Sofía. That's correct. German and Swiss law both recognize legitimate expectations as a protected legal category. Under German law, the protection is derived from the principle of legal certainty as well, mainly, which is considered to be part of the broader concept of the rule of law, which is, as in many other places, also an enshrined principle of the Constitution. The Swiss perspective looks at legitimate expectations a bit more through the prism of good faith, however, without any practical implications really following from that distinction. In the protection of legitimate interests in German law is closely linked to the concept of what is literally translated as administrative acts, which I understand is a concept that is actually heavily influenced by French administrative law. And I think these might be the specific administrative acts that Wesley mentioned. So under the way they take shape under German law is that this is a specific act issued to an individual that creates binding rights and obligations between the state and the individual. And that plays a very large role in the application of the concept of legitimate expectations in Germany. I'll come back to it in a moment. I'll just quickly say before I do that under German law, not all branches of the states, or not vis-a-vis all branches of the state, is the concept of legitimate expectations protected. Only vis-a-vis the executive and the legislative branches, not the judicial branch. The reasoning being that under the German view, the judiciary does not make law, and judges must be free to overrule previous decisions. The Swiss approach is not quite as rigid in theory, but there appears to be no or virtually no practical relevance of the concept in versus the judiciary. The way legitimate expectations are being applied is essentially pursuant to a four-pronged test that mirrors some of the categories that we've heard from Naomi and from Wesley. It starts with the first prong of the test is, was the expectation legitimate at all? Does it deserve legal protection? It does not if, for example, a concession was procured by through false representations, by corruption, quite obviously. The second part of the test, and there's a tension there is a difference to what Naomi said about English law. The second part of the test is, did the individual act in reliance on the expectation? That is, did it make an investment? So reliance is absolutely a necessary requirement. And then it just goes on, does the state have to refrain from changing the legal status quo because of the legitimate expectation? And here comes in a proportionality analysis. Does the individual interest in preserving the status quo outweigh the public interest in changing it? And if the answer to that is no, then the legitimate expectation can still lead to a claim for compensation. So there is the fourth prong is, even if the public interest justifies the change of the legal status quo, should the individual be compensated for any losses incurred in reliance? And some additional criteria have been developed specifically for executive acts and for legislative acts in that context. And for executive acts, German law distinguishes between the revocation of administrative acts that did not comply with the applicable laws, but were issued nonetheless, so errors, administrative errors, so to speak, and the revocation of administrative acts that were issued legally, but which the state seeks to cancel subsequently. And as you would expect, the requirements to revoke the administrative acts that did not comply with the applicable laws are less stringent than those for the cancellation of legal administrative acts, but both can give rise to claims for compensation for reliance damages. And that is something probably noteworthy. The claimant can only obtain reliance damages that is being put in the financial situation as if the act complained of had never occurred. That does not cover lost profits. And in that sense, is probably a difference from what we see under the FET standard. As for legislative acts, the jurisprudence of the German Constitutional Court distinguishes between what it calls retroactive laws. It's laws with a backdated effective date, and laws that only have a retrospective impact. But these are laws that only become effective going forward, but have some implications for acts already performed by individuals in the past. Retroactive laws are considered impermissible in most cases, and laws that only have a retrospective impact are typically permissible. With some exceptions, I'm conscious of the time, a noteworthy one is a legal German Constitutional Court case dealing with the German phase out of nuclear power, which is quite interesting. And as you may know, the German legislation changed its policy towards nuclear power several times in the last 2 decades. And whilst it allotted additional electricity production allocations to the nuclear power plant operators still in late 2010, it withdrew those allocations already in July 2011 after the accident in Fukushima. And in that context, there was considerable debate as to whether the nuclear power plant operators had legitimate expectations that some of the investments they made relying on the prolonged licenses for their power plants should be compensated. I'll stop here. I think I've exhausted my time.
Thank you very much, Tino. It's really interesting to compare the different systems. Eduardo, you are the last one, and you have a difficult mission, which is to give us the Latin American perspective. So a lot of countries, little time. What can you tell us?
Thank you very much, Sofía, and thank you, Laura, for the invitation to participate in today's session. As you say, Sofía, it's very difficult for me to be exhaustive about what can happen in Latin America, which is formed by many different countries and many different legal systems. So I'll limit myself to making three series of observations from the observation that I could undertake of what happens in Latin America. And first, I would like to address some issues of terminology or labeling in the region. Second, try to distinguish, to identify some common features of the relevant doctrine which is applied in Latin America. And finally, I would like to point to some differences that I found between the different regimes in the region. Regarding the terminology, something that surprised me at the outset of my quick search was that contrary to what I believed, France hasn't really influenced a lot the Latin American countries as far as legitimate expectations are concerned, because you find the doctrine, I'll come back to the labeling in a moment, but you find the doctrine in all Latin American states as applied by administrative courts and encompassed in administrative statutory law. Two terminological points. First, the word expectation, expectativa in Spanish, may be misleading because their Latin American countries are influenced by French law, and the word expectation is used to designate something which is not enough to be a right, a vested right. So there is a distinction that Wesley already mentioned between mere expectations and vested rights in order to decide issues of application of the law ratione temporis. So when any Latin American lawyer reads or hears the word expectation, his or her mind is immediately attracted to that distinction. So the real, and this is the second point, the real expression which is used in Latin America to label the doctrine we're speaking about here is confianza legítima, confianza legítima, or confiance légitime in French, or legitimate trust in English. So the search should be about how this doctrine is applied and not a doctrine of legitimate expectations. What are the common features of what I saw in the different regimes in Latin America? There are four interesting common features that I'll point out rapidly. First, the doctrine of legitimate trust is a protection that the law contains in favor of the citizens or private parties against acts of the administration. Second, the protection has as an assumption, which I found interesting, and we can comment on later, the stability of the legal regime. This is something that the doctrine says the citizens may expect. Third, the core of the doctrine is about consistency or inconsistency of the behavior of the administration and reliance on that consistency, which is breached when there is a sudden inconsistency. Nothing really new on that point. And lastly, which I found also very interesting in the region, is that there is a link between the legitimate trust doctrine and the principle of legality. The principle of legality states that public servants and the administration generally can only do what the law authorizes the administration or the public servants to do. So we may find there in that link the criterion of objectiveness of the legitimate expectations doctrine in investment case law, but we can comment on that later. And I come to my last point, which is about the differences that I found between the tests that you can find in different regions, in different countries in the region. And I should say that the tests are quite similar. And I would say, I mean, I'm more someone who studied private law more than public law. So it's very similar to the test that you find in the venire contra factum proprium theory. But there is a difference, which is important because you find it in Brazil, which is a very important country, even if it doesn't exist in the investment arbitration field. And the difference is that in Brazil, the test encompasses what Naomi and Tino explained, which is a proportionality analysis at the end of the application of the test. I didn't find a proportionality analysis as part of the test in the other countries. That's what I can tell in this limited period of time. Sofía, thank you.
Thank you very much, Eduardo. Yeah, there would be so many things to comment, but so in the interest of time, I will move on to the comparative discussion because I think that's also really interesting. From what we have seen so far, it seems that the protection of legitimate expectations arises either because it is recognized that the disappointment of an expectation may hinder an individual, or because there is a recognition that some legal certainty is necessary for individuals to be able to act and to exercise their decision making. And so thinking of how legitimate expectations has somewhat achieved protection and global recognition in most domestic legal systems. We will exclude the French legal system because it's a separate animal. Naomi, what do you think? To what extent is the concept of legitimate expectations recognized as a principle of public international law?
So this is a very interesting question. And I think the first thing to note is that the International Court of Justice has made it clear that the concept can't be held to exist in public international law simply because references are made to it in investment treaty arbitration awards. And that issue was considered in the court's 2018 judgment in the case Bolivia brought against Chile, claiming that Chile had an obligation in international law to negotiate with Bolivia on Bolivia's access to the Pacific Ocean. And one argument that was raised by Bolivia in that case was that numerous statements by Chile over the years had given rise to a legitimate expectation on its part that Chile would restore Bolivia's access to the sea, and Chile's refusal to engage in negotiations had frustrated its expectations. And on this point, Bolivia argued that the principle of legitimate expectations had been widely applied by arbitral tribunals in the context of investment protection. But the court said this was not enough to establish that the principle existed in international law at large. Now, as to whether the court would have reached a different conclusion if the argument had been put differently, well, then we need to think about what are the different sources of international law. And those, of course, are set out in Article 38 of the ICJ statute and include conventions between states, international custom, general principles of law recognised by civilised nations, and as a subsidiary means of determining international law, judicial decisions and the teachings of most highly qualified publicists of the various nations. The most obvious one to consider, as you've already alluded to, and given the discussion that we're having here today, is general principles of law recognised by civilised nations. And it seems from our discussion that there does seem to be some overlap between municipal systems, as you flagged, Sofía, albeit that France might be a particular beast. I mean, even though there's no concept of legitimate expectations per se in French law, there does seem to be some sort of recognition of a similar sort of concept across the different concepts that Wesley discussed. And also in Latin America, even though the concept's not called legitimate expectations as such, it obviously has similar content to some of the other systems. And putting it at its most general, perhaps then there seems to be sort of broad agreement that public authorities should generally behave with some consistency towards individuals. And if that's right, then perhaps we can say that there is a general concept of that sort of nature, although probably one would need to undertake a bit more of an in-depth analysis to know exactly what the contours were. And then if that is the case, then it would be possible to say that the concept of legitimate expectations is further supported then by investment treaty jurisprudence, although as you mentioned right at the start of this discussion today, how investment treaty tribunals justify bringing that concept of legitimate expectations into investment treaty arbitration is a little unclear, given that very few treaties actually mention the concept itself. Rather, tribunals have imported it into the fair and equitable treatment standard without really explaining why, as you mentioned. And the ICJ might have to give a view on this soon, quite excitingly, because it has two pending cases at the moment between Iran and the United States, in which Iran has argued that the fair and equitable treatment standard in the 1955 Treaty of Amity between it and the US encompasses the protection of legitimate expectations, and that the US has breached that provision. Whatever the ICJ concludes on the matter will, of course, be very instructive for everyone and for investment treaty tribunals as well. If there is an international law concept based on municipal law, then perhaps reading legitimate expectations into fair and equitable treatment could be achieved through Article 31(3)(c) of the Vienna Convention of the Law on Treaties, which establishes that together with context when interpreting a treaty, one should take into account general principles of international law applicable between the parties. But I think it's quite interesting that that analysis doesn't really come up, or hasn't come up, at least in the investment treaty cases that I've reviewed.
Thank you, Naomi. Yeah, it's really interesting, and I look forward to reading the decision of the International Court of Justice. So, okay, now focusing a little bit more just on international investment law and not in general in public international law. Wesley, can you tell us how have national concepts of legitimate expectations influenced or shaped the principle which is nowadays applied in international investment law? To what extent has the concept been inspired by any of the systems that we discussed earlier, or if you want to focus just on the French system, maybe, I mean, what you've already told us about the French-Colombian BIT is interesting, but in general.
Yes, it's thanks, Sofía. It's I must say it's a very broad question to answer in very few minutes, but there are not so many precedents when you think about it, where tribunals have been looking or referring themselves to domestic legal systems. It seems it was a given in the in a number of cases, but recently a few tribunals have nonetheless tried to get to the source of a concept. I was looking a bit at this in preparing the conference today, and there's one case which is interesting, which is gold reserve against Venezuela, and there was an award, final award in 2014, and in that case, the tribunal did refer to a number of domestic systems. I won't quote the whole section, but there is a paragraph 576 for those who are interested. The tribunal said there that so I quote, the concept of legitimate expectations is found in different legal traditions, according to which some expectations may be reasonably or legitimately created for a private person by the constant behavior and or promises of its legal partner, in particular when this partner is the public administration on which this private person is dependent. So that seems to catch quite a few things we've been saying since the beginning of this session. Then the tribunal goes on to say, in particular in German law, protection of legitimate expectations is connected with the principle of, Tino, I apologize, but I'm going to try have a go at it. Their Transschutz, which means protection of trust, a notion which deeply influenced the development of European Union law, pointing to precise and specific assurances given by the administration. Tribunal goes on and say the same notion finds equivalents in other European countries, such as France, in the concept of confiance légitime, which is what Eduardo was referring to in respect of Latin American countries. But when you look at French domestic law, confiance légitime or legitimate trust is not recognized as an autonomous legal principle compared to the other theories or concepts I've described, such as vested rights, legal certainty, etc. So that's interesting. Tribunals are making an effort, but when they do, it's not necessarily in accordance with the domestic system. So that's, I think I'll stop here, but that case is interesting. I didn't find so many, but this one was quite relevant, I thought.
Thank you very much, Wesley. Thank you. Yeah, so we are following kind of a plan like Eduardo with the common features on this side, and now we move on to the differences. So Eduardo, what are in your view the main differences between the protection of legitimate expectations in domestic administrative law and in the international investment context?
Thank you, Sofía. And I should say that the theories evolve all the time, and we have seen how the theory of legitimate expectation has evolved in investment case law. So what I can say today may be wrong tomorrow, and perhaps I hope so. So the difference I see myself are three main differences. The first one comes from what I said in relation to Latin America, which is that the doctrine of confianza legítima implies that the legal system is somehow stable. And if we think of, let's say, old investment awards, such as Sempra against Argentina or Enron against Argentina, and also TechMed against Mexico, we may get the sense that behind the notion of legitimate expectations, the arbitrators in those cases assumed that when the investor invested in the state, expected some stability of the legal regime. But we know now that this first version of the legitimate expectation theory has evolved. And to take one of the first awards that changed the theory, the El Paso versus Argentina award, as you all know, already said that the fair and equitable treatment standard and all the different components of it cannot be considered to be a stabilization clause as the one that we can find in some state contracts. So I feel that the theory as framed today in Latin America, implying this stability, is no longer accepted as such in investment awards. The second difference I see comes to something else that I mentioned, which is the principle of legality. And I find it's a pity that this concept, which is so important under administrative law, is not used to limit the theory of legitimate expectations. What is being used today is a bit vague, which is that legitimate expectations need to be objective. And objective seems to mean that each state entity can only make specific representations in accordance with the competence that that entity has in accordance with the legal system. But if we use the principle of legality, I think the limitation would be more precise. But I see a difference, even if the theory in investment case law and the theory in the countries in Latin America is perhaps becoming closer. And the last difference I found is that today legitimate expectations are limited by the idea that investors need to be diligent when they invest. And there might be an exception to the application of legitimate expectations in those cases where the investor didn't undertake a proper due diligence. There is a very interesting case on point, which is the case Gas Natural versus Colombia, in which you will find this analysis of how the doctrine of legitimate expectations as we know it today is not applied if it is established in the case that the investor didn't undertake a proper due diligence. So to conclude on this point, Sofía, I remembered that I had many years ago a conversation with both well-known arbitrators who happened to have perhaps created this doctrine of legitimate expectations in the first place. Francisco Rego Vicuña, who was the president in the Sempra and Enro cases, and Horacio Grijera Naón, who was the president of the TECMED against Mexico case. So it's quite remarkable that two Latin American lawyers created this theory. I will not. I know I should not be judgmental about this, of course. But the point of the conversation was this: I don't think they got inspiration from their local legal regimes, because the conversation at the time in a colloquium was about the case law of the World Bank Administrative Tribunal. The World Bank Administrative Tribunal, I'm told, has developed the doctrine of legitimate expectations, and it seems that since Francisco Vicuña was a judge there, and Horacio Grijera Naón had interactions with the World Bank, this is where they actually got some inspiration to develop that. Thank you, Sofía.
Thank you, Eduardo. That's such a good anecdote. I had no idea.
Just if I may, one very quick comment on that. It would be interesting to know how many people know that is the origin, and whether actually the way we're seeing the evolution in the decisions on legitimate expectations is becoming increasingly influenced by the domestic law doctrine, and actually maybe that's where we see an evolution and a tension between different decisions. And it would be really interesting to analyze all the decisions on legitimate expectation by virtue of who was sitting on the panel and from which legal tradition they came.
Definitely. I will ask a final question to Tino, because our time is limited, and it's a bit in line with what we've been discussing so far, which is, are national courts more reluctant to recognize the existence or the protection of legitimate expectations than investment arbitral tribunals? Do investment arbitral tribunals apply the concept more loosely without considering its roots or implications? This goes precisely a bit in line with what we've been discussing just now.
Thanks, Sofía. I think in some aspects, perhaps yes. I don't know, two come to mind. One is, and that is true for German and Swiss law, and I understood to some extent perhaps also for English law, I think some legal systems have a sort of entry-level threshold of specificity that a measure must satisfy before even being considered for to qualify for legitimate expectations claim. And in German law, there is this distinct category of the administrative act that sort of frames how the administrative, the executive must have acted to at least increase the chances of a claimant to have a claim. The concept of legitimate expectations is not exclusively limited to that, but a claimant will stand a much better chance. And I think those categories existing under international laws, creating a threshold, almost inevitably are missing at the international level because there is just no comparable universal administrative law. But it is a difference, I believe. And the second point would be what I can note from the German approach or Swiss approach to the legitimate expectations concept, that from the viewpoint of the remedy, it is different because the approach to only avoid reliance damages is somewhat different from international, from the application of the FET standard in the BIT. If you find a violation, then that triggers the full reparation principle normally, and then I think it's at least very much up for discussion whether a claimant can claim lost profits, and that can be an entirely different claim than just getting back the sort of out-of-pocket expenses as compared to the claims that we see with valuations going far in the future, DCF models. That is, I think, a quite large difference.
Thank you so much, Tino. Yeah, I fully agree with you. I'm so proud of us that we kept to our 1 hour schedule. I don't know if any of you wants to add something to what Tino just said, but otherwise I would just open the floor for questions. I don't think we have any question so far, but I may be wrong. And if in the meantime, if any of you wants to add something on the discussion, we're more than welcome to do it. Okay, so if there are no questions and no comments, I will just briefly conclude. Thank you so much for all of your interventions. It was really, really interesting. I learned a lot, and I think that we all look forward to hear what the International Court of Justice has to say. Oh, wait, we have a question. Rubania Nanda asks, will a cohesive and universal definition suffice in the context of legitimate expectation? Anyone wants to try to answer that?
I can start, and perhaps the others want to jump in. I guess it might not really only be a question of defining legitimate expectations properly, because given the application that the concept can potentially have, the definition would just have to be very broad, and then probably not provide the guidance that we're looking for to provide for a more consistent application of the concept. But that's just my first take.
Can I just add something to that very briefly? I tend to think that there shouldn't be a universal definition, because legitimate expectation of an investor when going into a country when you have to assess whether these expectations have been breached, you need to look at the domestic system, the domestic law, what was being promised to the investor, and from one country to another, it's a different, it's not the same thing. So I'm not necessarily convinced that a global or universal definition will make things easier. I think it should be looked at from a domestic prism all the time.
Thank you. Eduardo, did you want to say something? Did you want to add something else? No. Okay.
Well, I can add, coming back to what Naomi mentioned before, I recall an article by Francisco Rego Vicuña, which has been since probably forgotten, on this inspiration that he got from the case law of the World Bank Administrative Tribunal. I tried to find it, but I didn't. I'll keep trying.
Please do, and then circulate it.
Exactly. Okay, then yes, I don't think, I mean, I think that tribunals would very much appreciate having maybe a clearer definition, although sometimes maybe tribunals also appreciate not having a very clear definition and being able to adapt to the case, which is in the end also the goal of arbitration. So with this, I suggest that we conclude. Wes, if you are there, please let us know. Thank you so much, Naomi, Wesley, Tino, and Eduardo. It was very, very interesting.